Hello and welcome to African Elements and another installment on the series on Black politics. I'm Darius Spearman. In this episode, Nation versus State-Centered Power. How has the system of federalism, or the sharing of power between national and state governments, impacted African Americans in the political pursuit of universal freedom? What are the implications in terms of political strategy? We look at the circumstances under which nation-centered power and state-centered power have either favored or disadvantaged black political struggles. All that coming up right now. Federalism is the sharing of powers of government between the national or federal government and the governments of the states. There's an ongoing debate, however, as to where the balance of that power between federal and state government lies. The debate took center stage during the United States Constitutional Convention, which convened from May 25th to September 17th, 1787. Slavery was largely at the heart of that debate. During the Constitutional Convention, for example, the Virginia Plan proposed that the people as a whole elect the members of the House of Representatives. The House would in turn elect the Senate, the President, and the judiciary. A major sticking point, however, was that the Congress would then have unlimited powers, including the power to veto acts of the state legislatures. Obviously, the southern slaveholding states feared that the Virginia Plan, which gave the unitary government the power to negate all laws passed by the states, would interfere with the institution of slavery. The southern slaveholding states were ready to bolt if their interests were in any way threatened by the United States Constitution. The answer was not to directly mention slavery at all. Even so, there were some unavoidable issues that required that the framers spell out how the institution of slavery was going to be dealt with. State representation in the House of Representatives, for example, was to be determined by each state's population. The larger the state's population, the larger the number of representatives for that state in the House of Representatives. But what about slaves? Were they to be counted in the state's population for purpose of representation? For the northern states, who clearly wanted to stack the number of representatives in their favor and thus further their interest in the House of Representatives, the answer was clearly no. For southern states, who wanted to use the slave population to boost their representation in the House, the answer was clearly yes. Thus, the infamous Three-Fifths Compromise was enacted, which stated that representation was to include 3/5 of the slave population. Another issue that further defined the power of the federal government as it relates to slaveholding interests arose over the status of fugitive slaves. What if a fugitive slave escaped to a non-slaveholding state? What would be the status of that slave? Could a state impose its power over another state to protect its monetary interest in human chattel? Or would the federal government have to intervene on behalf of the state? Could the federal government intervene? Those questions were addressed in a fugitive slave clause that was inserted into the Constitution. The clause gave slaveholding states the power to cross state lines and retrieve runaway slaves that had made their way into free territories. What about the slave trade? What authority would Congress have in controlling the importation of slaves from the international slave trade? A constitutional clause banned any interference on the international slave trade over a 20-year period until the year 1808. So, after much wrangling and debate, the 13 former colonies that formed the 13 states of the Union determined to balance the powers of the national government and the states. The federal government of the United States had certain powers specified within the Constitution, such as the right to coin money, regulate commerce, or to declare war. By the 10th Amendment, however, those rights that were not specifically delegated to the federal government were reserved for the states. For African Americans, federalism has yielded mixed results. In theory, the advantage of the federal system is that it allows states to serve as laboratories for public policy innovation and experimentation. A recent example of state initiatives that have forged ahead of federal policy would be the issue of marijuana legalization. In 1996, California became the first state in the Union to legalize marijuana for medical use when voters passed Proposition 215. Several states followed suit in the ensuing years. In 2012, the states of Colorado and Washington legalized the recreational use of marijuana for adults 21 years of age or older. Over the next 5 years, Alaska, Oregon, California, Nevada, Maine, and Massachusetts also legalized the recreational use of marijuana through state ballot initiatives. All told, 28 states, as well as the District of Columbia, have enacted some form of marijuana legalization. State legalization has occurred even while marijuana remains classified as a Schedule I narcotic as defined under federal law by the Controlled Substances Act. Given the devastating consequences the war on drugs has had on African Americans since the 1980s, efforts towards the legalization of marijuana could help to mitigate the enormous toll that mass incarceration has wrought on Black Americans. On the other hand, leaving the process of policymaking in the hands of state lawmakers has often yielded undesirable results for African Americans. The most obvious example would be the issue of slavery. Until the Civil War, slavery and the rights of African Americans was mostly a matter decided strictly by each individual state. Even in non-slaveholding states, free blacks were often relegated to slave-like status. In California, for example, the delegates of the 1849 State Constitutional Convention decided unanimously to exclude slavery within California's borders. Still, African Americans were not allowed to offer testimony in California courts until the year 1863. Blacks gained voting rights in California not through state action, but only after the 15th Amendment was added to the Constitution in 1870. Additionally, blacks faced legal segregation in California schools until the year 1890. Oddly, even as the California Constitution made California a non-slaveholding state, the California legislature passed its own fugitive slave law, which went even further than the National Fugitive Slave Act of 1850. In spite of California's ban on slavery, the 1852 Fugitive Slave Law essentially gave license to slave owners to bring slaves into the state. While the National Fugitive Slave Act granted enormous powers to slaveholders to retrieve slaves who had escaped to non-slaveholding territories and required citizens of non-slaveholding territories to cooperate in their return, California's Fugitive Slave Law upped the ante even more. The California law didn't even require that so-called fugitives be runaways. In other words, in California, which was ostensibly a non-slaveholding state, slaves had no claim to freedom even if they were brought to the free state by their slave owner. Even after slavery was abolished by the 13th Amendment of the Constitution in 1865, states of the former Confederacy systematically passed laws that ensured the continuation of the exploitation of black labor. Such laws included the Convict Lease system, which allowed prisoners, almost exclusively black prisoners, to be leased out to private interests. Vagrancy laws acted as a dragnet to round up newly freed men and women who could not prove that they were employed. It was against the law throughout much of the South for a black person to leave the employment of one landowner to work for another landowner without the permission of the first landowner. Under child apprenticeship laws, black children from age 2 to 21 could be removed from black homes and placed as free laborers in white households for reasons as arbitrary as it being in the best interest of the child. Although the 14th Amendment ostensibly granted citizenship to all persons born within the United States, including former slaves, the Jim Crow regime quickly spread throughout the southern states, relegating blacks to second-class citizenship at best. A system of rigid segregation was installed in which black and white facilities were separate and unequal. Throughout much of Southern society, the absurd system of Jim Crow segregation segregated blacks in every area of society from the cradle to the grave. That is, blacks were born in separate hospitals and buried in separate, segregated cemeteries. The absurdity of the system was manifest in everything from segregated transportation systems, waiting rooms, drinking fountains, and swimming pools that designated specific days for whites and blacks whereas the pool on Sunday was completely drained so that white children who swam in the pool on Monday would not have to suffer the indignity of swimming in water that had touched black bodies. Other examples include the issue of welfare reform. During the Great Depression of the 1930s, President Roosevelt initiated federal policies that guaranteed income for the poor, elderly, and disabled with the Social Security Act of 1935. Those programs were expanded under the Johnson administration in the 1960s, but the Personal Responsibility and Work Opportunity Act signed by President Bill Clinton in 1996 established block grants that would allow federal monies or welfare programs to be administered and dispersed by the states. The result was a far more draconian welfare system that allowed the states to establish extraordinarily punitive criteria for distributing assistance to the poor. One might recall the efforts from several states to ban steak and lobster from the food stamp program. In an even more absurd example, the state of Florida led efforts to force mandatory drug testing of all welfare recipients. A segment on The Daily Show with Jon Stewart in 2012 covered that topic in absolutely brilliant, poignant, and hysterical fashion. It's about a 6-minute clip. I'd highly recommend checking it out at the link below.